All right, good afternoon, everyone. Thank you for attending and welcome to the PACE Compliance Educational Video Webinar entitled Updates from the Bar, where the TCPA Defense Counsel will discuss the latest trends in the courts, presented by Innovista Law. I am Maudrey Godfrey, VP of Business Development for PACE, and will serve as your moderator. As we prepare to begin, there are a few housekeeping items I'd like to inform you of. The webinar is being recorded. All participant conference lines are muted. Up on the start of the video, please mute your conference line and turn your computer mics up. You may unmute your conference lines during the Q&A session at the end of the video, where we'll be taking questions during that time. So feel free to type any into the chat box located in the lower right-hand corner of your screen. We'll attempt to answer as many questions today. And those that we can't get to, we'll send an email response. There is a polling question today in the upper right-hand corner of your screen, and you'll be prompted when to respond. Please allow me to introduce our speakers within the video and live during the presentation. Attorneys Joe Bowser and Martin Caniff, both partners of Innovista Law, will talk a bit about their career journey and then jump right into the bar updates.
Hello, my name is Martin Caniff. I'm with Innovista Law and, of course, the TCPA Defense Force. I've been a litigator for almost 30 years and have now focused on the TCPA, one of the strangest statutes we've ever seen. Joe, let me have you introduce yourself.
Good afternoon, fellow PACE members. My name is Joe Bowser. I'm also a partner at Innovista Law and another co-founder of the TCPA Defense Force. I have spent the last decade immersed in TCPA litigation, compliance counseling, and message auditing on behalf of a number of brands, banks, insurance companies, and mobile marketing platform providers.
And we should also introduce the TCPA Defense Force. Really, it's just a branded practice group from our law firm, Innovista Law, but we wanted to show the community that we're focusing on the defense of TCPA. We also do training, counseling, compliance, as well as, we mentioned, litigation defense. But we wanted to start out today with maybe a quiz. Like I said before, the TCPA is the strangest statute I've ever seen, but who else has said that the TCPA is the strangest statute? Your choices are A, Chief Justice John Roberts, B, Judge Judy, C, Aaron Judge, or D, all of you in the audience. Joe, do you care to take a guess?
I'm in the audience on this one.
Great. Well, we'll reveal the answer at the end as perhaps an incentive to sit through to the end. But what we're going to do today is talk about developments in the courts and the agencies on the TCPA. There's been a lot happening and a lot that's going to happen in the ever-changing landscape of TCPA regulation. Now, we know for most of you, at least, on this webinar, the TCPA is really a nightmare. And why is that? Well, first of all, it's one of the few regulations that includes what are called uncapped statutory damages. So a plaintiff doesn't have to prove their actual damages. Like, say, if you were in a car crash, you'd have to prove your medical bills, your pain and suffering. Under the TCPA, even if a call may have taken 2-3 seconds out of your life, you're still entitled to $500 per violation, or if a court rules that it's willful, it could be as high as $1,500 a violation. And you can see those can really add up on even a modest telemarketing campaign. The other problem that makes the TCPA a nightmare is the expansive regulatory reach. This is an area that's frankly very popular with the American public to rein in. They don't like getting unwanted communications. So the regulators have taken their cue. Both the FCC and the FTC have expanded their reach over time into kind of all aspects of marketing communications. Joe, are there other reasons TCPA has turned into a nightmare?
Well, the first one that you mentioned, uncapped statutory damages, has created another problem, which is the cottage industry of plaintiffs' attorneys and professional plaintiffs who have a well-oiled machine to attract plaintiffs, prospective plaintiffs who have allegedly been injured by these unwanted messages, and as well as the professional plaintiffs who are going their own, cutting the plaintiffs' attorneys out of the mix and filing their own cases. The plaintiffs' attorneys have established apps so that they can attract plaintiffs. They've got websites, TV commercials. They are marketing this as though it were a genuine product designed to cure some harm, but when in fact they're really, just chasing their next yacht. As I mentioned, there are a number of professional plaintiffs who have multiple phones. They keep call logs. They are waiting for you to call, and they have got their cookie cutter complaint sitting on their desktop, waiting to put your name as the next defendant and file it in federal or state court. So there are a number of bad actors who are essentially attracting these alleged harms that they're suing about. The other difficulty that makes the TCPA compliance a nightmare is that it's essentially impossible to comply perfectly. As everyone watching probably knows, the numbering databases are not perfect. It's not clear when a number gets ported from wireline to wireless. It's not clear when a number gets changed from user A to user B. It's certainly not obvious when numbers are VoIP numbers for which the subscriber incurs a charge for the call. So there are a host of issues that make it difficult, if not impossible, to comply perfectly with what is essentially a law that requires perfection.
Great. Well, let's jump in and start talking about some of the recent developments in court and agency rulings on the TCPA. Joe, some of the knottiest issues regarding the TCPA revolve around consent and revocation of consent. In fact, it's bewildering sometimes given the different factual circumstances. Can you tell us what's been going on in that area recently?
Sure. One of the biggest cases that has come out in the recent months is a case out of the Second Circuit, which includes New York most prominently. It's a case called Reyes, which you may have heard about. The case dealt with a situation in which Mr. Reyes took out a lease for a luxury Lincoln car, was good on payments for a little while, defaulted pretty soon after taking out the lease, and Lincoln, understandably, began to call him to collect on the debt. They called him a lot. They called him over 400 times, and somewhere in there, he sent Lincoln a letter. He allegedly sent Lincoln a letter. Lincoln never got it, but he said that he sent him a letter saying, "You need to stop calling me. I revoke my consent, if I gave you any, to call me." Lincoln continued to call to try to collect the debt, and sure enough, he sued Lincoln for violating the TCPA. At trial, the court said there was no evidence that you revoked because Lincoln never got it, and you couldn't prove that you actually sent this letter. So he kicked the case. It went up on appeal, and the Second Circuit said, well, that revocation issue really should have gone to the jury, but Lincoln, you still win because Reyes never could have revoked his consent in the first place. So because he had signed a lease where he had given written consent to be called about the lease and about his automobile, the Second Circuit said, it's not for you, Reyes, to pull out a term of the agreement that was part of the bargain. You can't revoke your consent any more than Lincoln can say, I found somebody over here to pay more for your car, so Reyes, sorry, I'm going to come take your car and give it to Johnny over here who's willing to pay me a few bucks more. So the Second Circuit said, once you've given written consent to be called as part of a contract, you actually can't revoke your consent.
Well, Joe, that all sounds great, but does it matter?
It's hard to take Reyes to the bank. The important issue to remember is while customers can revoke consent given in writing, there are also separate DNC, do not call list rules, also within the TCPA that have their own obligation to accept and acknowledge company-specific opt-out requirements. So while the Second Circuit opinion is important and it's a good defense that all good defense counsel should keep in mind, companies still ought to honor opt-out requests when they're given appropriately.
Well, sounds like Reyes might be tough to rely on. What have other courts done on this issue?
There are two other important issues regarding consent and revocation that have been troubling the courts lately. One deals with application developers. Courts have been struggling to figure out when an application developer sends a message that the recipient may or may not have consented to, and when the user of the application has initiated or sent the message that they're friends or contacts may have consented. And the way the courts have been coming out in the application context is really looking at who's deciding to send the message and who's effectively hitting send. So they're really focusing on the initiation question. So if a user downloads an app and begins to use it, and the app, without the user's knowledge or consent, actual knowledge or consent, sends out a message to the user's contacts, effectively saying, hey, Johnny's downloaded this new app, it'd be great if you interacted with him through our new app. Courts are looking at that as seeing the app as promoting itself rather than Johnny engaging with his contacts. On the other hand, if Johnny actively selects which contacts or when they get that message saying, I've downloaded this new app, I think you'll like it too, courts are saying, okay, Johnny was the one who ultimately chose to send that message, and then they look to Johnny to decide whether the consent was given to receive that SMS, even though it was generated out of the app. Another issue that courts are struggling with is, as you mentioned earlier, the FCC's extremely broad definition of how a consumer can revoke their consent under the TCPA. As you'll recall, the FCC thinks that consumers should be able to opt out via any reasonable means. Not a lot of teeth or meat or bones put on that skeleton, but so courts have been struggling with how practical of a limitation we can put on what those reasonable means are. So some courts have seen situations where a plaintiff remembers talking to someone in a given month, and the court says, kind of like in the Reyes case, that's enough. We've got a dispute of fact here. Yes, the defendant has call records and they've got detailed logs and accurate contemporaneous business records about what the given agent had communicated with the user about. But this person has testified under oath at deposition or an interrogatory response that he remembers revoking consent. Courts have often said that that's enough to send that question to the trial, which of course ratchets up the cost and makes settlement more likely. Other courts have said, look, the defendant has really good contemporaneous business records that show that there wasn't a call. Yes, the plaintiff has some vague recollection about a telephone call, but I need to see more than that to send the case and the defendant to an expensive trial that's going to bog down the parties and the court in what is turning out to be very expensive, very time-consuming litigation, and particularly in cases where class action certification is being sought, those kinds of individualized issues about who remembers talking to who when and what they talked about doesn't make class certification appropriate and is a good way for the TCPA class defense counsel to drive a wedge between the named plaintiff's case and the rest of the class case. So the application context and the vague recollections of consent have been areas where courts are struggling to try to deal with the vagaries of the FCC's 2015 omnibus TCPA order that's now on appeal at the DC Circuit.
Well, I know there's often difficulty figuring out if a campaign is informational or promotional. Have there been any developments in that regard?
Courts have been struggling to determine when a given message or call has an informational component or whether it has advertising or telemarketing components that ratchet up the consent requirement to prior express written consent. As you'll recall, informational messages only require you to have received the user's telephone number in the context of the given campaign in which you're actually calling the consumer. If you're going to be making advertising or telemarketing campaigns, you obviously need prior express written consent where the written agreement contains all of the required disclosures and disclaimers that the FCC required back in 2013. So there are some clear cases where if you're advertising that you should go to your local Wawa or A&W for a root beer float, sure, that is a marketing message that requires prior express written consent. On the other hand, Anthem of California was deemed to be making informational calls when it pushed out a pre-recorded campaign reminding users that their next year's plan was going to change, telling them about different features, inviting them to check their mail and learn more about the different plans that they could subscribe to under the Affordable Care Act. So different courts are struggling to deal with that. Similarly, courts are struggling with how to handle mixed messages. So on the one hand, going to your Acura dealership, getting your car serviced, and then getting a customer service call to find out how you would rate your experience, that court deemed that call to be promotional, even though nothing was sought to be sold or promoted, and they genuinely wanted to know what your experience was like. That court said, well, your end game is probably to get them back to the dealership, whether to buy a new car or to choose them for service again in the future. Other courts have found similar customer service messages to be just that. You're really looking for feedback about how to improve your service, and then if they can't connect a sales cycle in that call, they say, okay, that's going to be an informational call, and provided you got the call when they dropped off their keys for service, or said, yeah, I'm interested in learning about a State Farm insurance brokership, some courts have said that I'm going to put that on the informational side of the line. So here again, it's really important to be focused on which court you're in, which appellate circuit has issued opinions that will help guide the trial judges in those courts. And then even then, within a given court, like the Northern District of Illinois, for example, different judges have come out very differently in terms of these arguably mixed messages or mixed calls where there's an informational component and arguably a sales component, because of course every business at the end of the day is in the business of making money one day.
I've noticed that plaintiffs have gotten creative on trying to evade the TCPA, especially with revocation of consent. Have you seen anything in that regard?
Yeah, so I mentioned the Reyes case where he sent the letter, he doesn't, no one got it, he doesn't remember, he certainly didn't send it certified mail, he has no evidence that he sent it. So there are these mystery revocations. I've had cases where the plaintiff has essentially engaged in poetry with the SMS platform. The SMS platform is, of course, a robot that's designed to respond to certain keywords like stop or help, and it knows how to respond to those things, but it doesn't know how to respond to messages like, it would be lovely if you removed me from your list next Tuesday. Or I've had plaintiffs who subscribe to a given campaign and then through another telephone number say, stop calling me, as though the SMS platform knew who the me was. So I've been embroiled in cases where you've got to get to the bottom of who this plaintiff is and then get back into your call logs to figure out who these people even are and whether there's any bona fides to the fact that they claim to have revoked consent. So the SMS poetry is a big trend among professional plaintiffs, and so is the mystery revocation, where it's difficult to pin these people down, which takes the case out of motion to dismiss territory where you can get them knocked out pretty quickly and pushes them back to hopefully just summary judgment territory where you can tell the judge, we've got the body of factual evidence at hand, here it is, Your Honor, even on these facts we win. So pinning people down on consent and revocation has been challenging because the plaintiffs are coming up with more and more creative ways to muddy up the record to make it hard to kill a case early.
Great. Well, thanks for that summary. It's an interesting area, and we'll see what happens in the future.
Martin, I mentioned the FCC's 2015 omnibus order during our last segment. Everyone's on pins and needles waiting for the D.C. Circuit to issue its ruling. When can we expect it, and what do you expect to see?
Well, great question, Joe. I know everybody's waiting on this one. The panel had oral argument back in October, and it was very interesting seeing the questions and how they responded to it. Of course, it's always difficult to predict how a court will rule based on the oral argument. Based on the typical case in the D.C. Circuit, this one is overdue. Many cases have been stayed pending the D.C. Circuit's ruling. The D.C. Circuit ruling would apply nationwide because the D.C. Circuit is reviewing the FCC, so it'll apply to courts across the land. And of course, understandably, lower courts have been waiting for this important guidance. One thing that could happen, even though lower courts are waiting for guidance, the D.C. Circuit could send back issues to the FCC. They could decide one or more issues need more work from the FCC and send it to the FCC with some or perhaps no real understandable guidance, which certainly has happened in the past. Now, given the current makeup of the FCC, we would expect that we should see more defense-oriented rulings. Of course, it's always tough to predict the future, but we can predict that this will be an important decision no matter what. There's three major issues that were addressed in the briefs and addressed in oral argument. The first is the auto dialer issue, and the FCC's order says that any device with the potential to be an auto dialer would be considered an ATDS. Now, the panel of judges on the DC Circuit struggled with this. In fact, one judge even asked if her iPhone would be an automatic dialing device because there probably are apps you can download to make it an auto dialer. So we think that the DC Circuit will do something on that issue and maybe tighten up the definition. They certainly felt uncomfortable with the broadness of the FCC's order. And maybe, again, this is one they send back to the FCC, see if they can tighten it up.
What else is on appeal?
Well, there's the issue of revocation, which you've talked about earlier, but the FCC order says, you can use any reasonable means to revoke consent. The problem is there's no bright line test. So, if a consumer tries to revoke by talking to a cashier, or as Mr. Reyes, sending in a letter, or sending back a very creative SMS text, it's really burdensome for a large company to keep track of that because it might be coming in different channels and different forms. And again, I think I attended the oral argument. I saw the panel wrestle with, certainly it sounds nice to say use any reasonable means, but given the volume and the types of these communications, is it really fair for a marketer to kind of have to go out and keep track of a plethora of different ways of revoking consent? So expect the DC Circuit to provide some guidance on that and hopefully a bright line test that marketers can follow. Another major issue the DC Circuit will address is that of reassigned numbers. There's about 100,000 numbers a day that get reassigned, and the technology to track that isn't perfect by any means. So the FCC order provided a safe harbor of one call, which means a marketer only has one call to determine that a number no longer belongs to the person it's trying to contact.
What if they don't answer?
Well, exactly. It's pretty tough to nail down whose number it is, especially when a lot of professional TCPA plaintiffs make it a habit of not answering their phone and let the calls accumulate. So we expect the DC Circuit, hopefully, to issue some guidance on the reassigned numbers. Certainly at oral argument, it was an issue that they spent a lot of time on and they seemed concerned about. So those are the three major issues we hope the DC Circuit will address, but there may be other subsidiary issues or an overall tone of how the FCC should handle the TCPA and its regulatory framework.
Thanks for that, Martin. Turning the page here, Dish Network has been in the news lately a lot, not always for the right reasons. As everyone has seen, they got hit with an eye-popping 9-figure civil penalty recently. What happened and what lessons can we learn?
Sure, there's a lot of lessons to be learned from this case. In a 475-page opinion that was quite extensive and thorough, a federal district court found Dish liable for $280 million in civil penalties. And what the case involved, the case was long running. It went for over 10 years, I believe, and it was the FTC and various attorney generals from different states pressing claims against Dish for various violations of the TCPA. The violations included calls to the Do Not Call registry, violating the call on abandoned numbers, but most particularly involved Dish's failure to supervise both its retailers and its marketing agents. And the court was quite concerned with Dish's cavalier attitude towards its agents and whether they complied with the TCPA. To say that TCPA violations could add up quickly is really an understatement. In the Dish Network case, the court found that there were 66 million violations, and the potential penalties added up to $8.1 billion. And in fact, the various government regulators, like the FTC in the states, were seeking $2.1 billion in fines. Ultimately, there are some lessons from DISH, even though your company might not be facing $8 billion worth of penalties, but the penalties add up very quickly and need to be taken very seriously. First lesson is that training is essential. The real breakdown here was on the front lines with DISH's retailers and marketing agents not really being sensitive to, or perhaps not even being aware of, the regulations under the TCPA. Another lesson from the DISH case is to keep good records. DISH found itself having trouble defending itself because it kept poor records. It didn't have the best records it could have of scripts, outline of marketing campaigns, and communications to its retailers and agents. So if you're in this business, it really behooves you to keep good records of your compliance efforts, what you're doing in your campaign, and especially your communications with your marketers, agents, and retailers. Another lesson, which should have come through already, is that you're responsible for your agents, including your retailers, telemarketers, ad agencies, marketing agencies. Throughout the opinion, the Federal District Court showed its exasperation with DISH's failure to really even care what its agents were doing. In fact, in the opinion, the court a lot of times said that DISH was willing to let its retailers do whatever it wanted as long as they produced the results. And frankly, the regulators, federal district courts, are not going to put up with that attitude. So if you think just because it's your retailer or a marketing agent doing it and your company's not responsible, you'll be sorely mistaken. The last lesson from the DISH Network case is to take customer complaints seriously. Throughout the record, there were numerous customer complaints that came into DISH about its retailers and marketers' actions, and DISH really did not take these very seriously. In fact, there were internal communications at DISH really treating these in a very offhand manner, and frankly, even sometimes ridiculing their own customers. The court did not find that humorous at all. So if you find yourself mounting a large campaign and using agents such as marketing agencies or retailers, and you're starting to get complaints from their customers, take them very seriously, because the regulators will.
Martin, I often hear clients ask, well, I've got an indemnification clause in my contract with my third-party marketer or call center. Aren't I off the hook because they've agreed to defend and indemnify me?
Well, there's a couple problems with that. One, if you think your marketing agency can foot an $8.1 billion civil penalty, then sure, rest easy. But the reality is a lot of marketing agencies, retailers are not going to be as well capitalized maybe as the company you work for. And it may be all well and good to have their promise to pay you, but the fines might be so substantial that they may not be able to cover it. And also, like in DISH, the court may just cut through that and find primary violations based on your company's involvement, your company's supervision of the campaign, which would then make any indemnification not as effective as it might be. So you can certainly write that into your agreement, and you should, but don't take that for a license to close your eyes and ignore what's going on.
So we can't sleep easy just because of an indemnification provision.
Exactly.
Martin, about a year ago, everyone was putting great hope in the Supreme Court's Spokio decision. A, how do you pronounce Spokio? And B, how have the lower courts dealt with the Supreme Court's Spokio decision?
Well, the first one's easier than the second one. We did go to the company's blog, and evidently it is pronounced Spoke-E-O. So we'll go with that pronunciation. And yeah, there were great expectations that the Spokio Court's case would allow defendants in a TCPA case to raise a defense of standing. That is, under the Article 3 standing requirements that's needed in federal courts, that plaintiffs in a TCPA case might not have concrete injury enough to bring the case. Unfortunately, Spokio was decided over a year ago, a little over a year ago. Since then, there's been a number of court decisions, and they've almost all ruled that a plaintiff in a TCPA case does have sufficient concrete injury to bring a case in federal court.
Even if they don't answer their phone, even if they didn't even know it rang.
That's exactly right. Spokio has not been effective in defeating standing in TCPA cases. And the reason is that one of the categories courts have carved out to show that a plaintiff has concrete injury is whether the cause of action would have been traditionally recognized at common law.
What does that mean?
Well, it means that to show concrete injury under a statute, the court will, one of the way the courts will analyze it is to look back and see if that type of action had traditionally been recognized. And in TCPA cases, an invasion of privacy has traditionally been recognized as a tort under the common law. So what the courts say is that since invading privacy has traditionally been recognized in giving somebody standing, it's certainly enough to give them standing in a TCPA cases.
So I'm invading someone's privacy when I send them a message that they read on the subway?
Yes. And that's the overall concept, is that the underlying injury in a TCPA case is invasion of privacy. And since courts have traditionally recognized that, you can't use Spokio to defeat standing.
So the lower courts haven't found any cases that fail to meet Spokio?
The numbers are kind of daunting. There's been, since Spokio was decided, there's been 77 cases analyzing it in terms of the TCPA. In 67 of those cases, courts found that there was concrete injury and that there was standing. In 10 of the cases, however, courts did find there was no standing. But if you go in and read the cases and analyze them, you'll see that almost all of them involved really either a failure to plead some type of concrete injury or pleading very conclusory allegations. So even the cases that you might pin your hopes on and finding no standing, really upon further examination are not much help at all because they involve extreme facts or a failure to plead correctly. So there was an 87% rate of courts finding concrete injury, but even analyzed more closely, it might be 98 or 99%. So very little comfort from Spokio to defeat a TCPA case in federal court.
So the outliers there are really plaintiffs' attorneys who are a little asleep at the wheel, as it were.
Yeah, asleep at a wheel or lazy, just a failure to, set out in detail the facts of concrete injury. So it's kind of easily, even if the court rejected it, it's probably a case where it's easy to amend your pleadings and get it right the second time around. So unfortunately, there were a lot of hopes for Spokio to defeat these type of cases. It really fizzled out and is not much help, at least in this arena. It has been applied to other federal statutes.
So Spokio is in the dustbin of history for TCPA purposes?
Essentially.
Thanks.
Joe, there's lots of businesses and even consumers that have been using VoIP lines lately. But again, this strikes me as an area where perfect compliance is difficult, if not perhaps impossible. What's been happening with the courts in that area lately?
You're right, Martin. VoIP is definitely a thorny one for TCPA compliance purposes. VoIP has a number of hybrid qualities that straddles a number of important regulatory categories for the TCPA. For example, as you mentioned, VoIP can be used both on the residential and on the business side. And of course, TCPA regulations vary based on whether a given line is residential or business. VoIP lines can be metered. You can pay per minute, which is more common on the business side, but it can also be unlimited. So there you have situations where the consumer may or may not be charged for the call. There are also VoIP services like Google Voice where there are no charges, but none of this is transparent to the caller. Similarly, you can have VoIP lines where it's like wireless in that the given area code has nothing to do with where the person exists. So you can have time of day problems when you're deciding when you can permissibly call a given number. And when you don't know that it's VoIP, you lose the ability to really tether a given area code to a geographic location. So with all that said, VoIP is an emerging issue in the TCPA case law. And importantly, there was a case called Klein recently where the court went through a very thorough analysis to decide how to think about VoIP lines in the context of TCPA. And the court did a good job of highlighting the various regulatory categories that this technology is straddling, and he acknowledged that the VoIP lines can fall within that catch-all provision of other telecom services for which the user is charged for the call. Now in this case, it turns out that the plaintiff was using a Google Voice line, which is entirely free to at least this plaintiff, and so the court was able to comfortably conclude that even though the catch-all could apply to VoIP, it didn't apply to this plaintiff. But I see that as the writing on the wall for the next set of plaintiffs' attorneys and professional plaintiffs to go get their Vonage line, get a Google Voice line where they may get incur a charge for the calls, and then start filing the cases based on that new area of the law. Similarly, you had mentioned Dish Network earlier. Dish had made a challenge to the constitutionality of the TCPA because the numbering administrators don't do a good job of taking numbers that they knew to have been assigned to VoIP that no longer are being used out of the do not call list. So even though the numbers should be removed from the list, it's not their practice to remove unused VoIP numbers that they know are not assigned from the list, because presumably they're being assigned to third parties down the chain, whether as VoIP or typically the CLECs, the competitive local exchange carriers that provide telephone numbering resources to VoIP companies, which raises another issue that I expect to see coming up in the courts, and we may get to it later today. There's no good resource for parties to use to know whether a number is assigned to a VoIP service. Unlike landlines and wireless numbers, where the numbering administrators have a good sense of which type of carrier gets those numbers, in the VoIP context, many VoIP providers just get their numbers from CLECs and push them out to their consumers or resellers, and there's no good tracking mechanism for determining whether you're about to hit send on a message or a call to a VoIP line.
Well, it sounds like the hybrid nature of this technology is really creating some problems.
And it's definitely something that we ought to revisit with the FCC as they begin to look more thoughtfully about how businesses that are well-intentioned and want to comply can comply.
Great. Well, thank you, Joe.
Martin, throughout our discussion today, we've talked about the interplay between the agencies and the courts. The courts obviously look to the agencies for guidance about how to handle these regulatory issues, but clearly the regulatory agencies are the ones that are chiefly tasked with pushing out the regulations that are supposed to guide the courts. What do you see going on at the agencies lately?
Well, the FCC, there's been a number of new and interesting developments. In fact, they all happened on the same day, June 22 of this year. One is the FCC kind of flexed its regulatory muscle. It initiated an action for $120 million in fines against a marketing agency who committed, I guess, 96 million spoofed calls in a 3-month time period. So certainly a bad actor in this regard, but interesting that the FCC is making it clear that just like the FTC, it has the ability to seek fines, and it will certainly when a very bad actor is in play. So with a new makeup on the FCC as of this year, 2 Republicans to 1 Democratic commissioner, we expect to see some changes and maybe a realignment in philosophy. One thing the FCC also did was send out a notice of inquiry on potential technical solutions to authenticate caller ID. And this is interesting because we're starting to see efforts by the FCC to come up with practical technical solutions to some of these problems. So instead of having a quagmire exist in litigation in the courts and, kind of burdensome litigation costs, the FCC is really trying to push for technological solutions and figure out, at least in this case, how to authenticate caller ID, which of course would help end some of these spoofing calls and other abuses. Another important notice of inquiry that was sent out by the FCC on the same day was seeking technological solutions to track the reassigned numbers. Like we said before, there's about 100,000 a day. 35 million numbers a year are disconnected. So this is a huge problem, as most of the people in the audience know, for people trying to comply with the TCPA and the Do Not Call registry. The FCC sent out a request that companies and technology providers, everybody in the industry, to comment on possible technical solutions for tracking the reassigned numbers. So this, again, another indication that the FCC is trying to come up with workable, pragmatic solutions rather than playing gotcha, where even the most meticulous company trying to comply with these regulations would have trouble if there's no real acceptable and foolproof way to track reassigned numbers. And like we talked before, under the current FCC order, company has only one call to determine if it's calling the right number. So this is kind of a welcome sign from the FCC that instead of getting bogged down in sort of a very heavy-handed regulatory regime, it is open to looking at technological solutions to some of these problems.
Any indication yet on when we can expect any agency action on these more market-driven proposals?
No, that process is just getting underway. Various actors in the industry will be able to submit their comments and ideas, and there'll probably be at least some open hearings on that, and of course staff work. So it will be in the future, but it's a welcome sign that perhaps everybody, the regulators, people in the industry, various lobbyists and political causes can kind of come together and say, listen, this litigation nightmare isn't making sense for anybody, and ultimately the consumers pay that as a tax anyway. And if we can come up with very good technological solutions to this, we can avoid the problem altogether.
Do we think the technology is already there, or is that still in flux as well?
That's still in flux too, but every day it seems to get a little better. And with a regulator like the FCC pushing for solutions, that helps, that perhaps resources will be devoted to that. And certainly if there's a monetary incentive, one would hope somebody could come up with the technology to solve the problem.
Certainly. Thanks, Martin.
Thank you. Well, that's our discussion of what's been happening in the courts and the agencies on the TCPA. We hope you found it helpful. Of course, we understand it might be confusing at times because, hey, it's confusing for us too. But I think by looking at it, analyzing, thinking about it like we do all the time, we can help you guide you through the changing landscape of the TCPA. We do have two resources that we've put together. We call them the TCPA Survival Guide. One is our Rules Edition, and the other is our Litigation Edition. If you'd like to download those as ebooks, you can just go to our website, tcpadefenseforce.com. We've also put together some training. Do you want to talk about that a little, Joe?
Sure. It's an innovative training session designed to introduce your team to the various areas of exposure to TCPA liability, and it is meant to coach them on the key aspects of TCPA compliance that they need to worry about in their everyday work lives. It's hosted on an innovative learning management system where you can track who's taken it. There's a quiz afterwards to make sure that there's a good level of understanding and comprehension for those key TCPA rules for your marketing team, and it's a wonderful resource that we're very, very proud of.
Now we're going to open the floor up to some questions, but if we don't get to your question or you think of a question later, feel free to contact us at tcpadefenseforce.com. We'd be happy to spend a little time with you and try and address your concerns. So thank you very much.
Thanks, everyone.
All right, thank you so much, Joe and Martin, for a fantastic and very informative discussion. We're going to open the floor now for questions. We do have one from Glenn. Thanks, Glenn, for submitting your question. And literally during your Spokio discussion, Joe, Glenn is wondering, what about the Twilio case in the D.C. Circuit Court this month? And is that why the motion to dismiss didn't go through? So if you want to go ahead and respond to that, we'll wait.
Sure thing. I hope everybody can hear me well. Thanks for joining. The Twilio case, as Glenn rightly notes, came out of Seattle, let's see here, on the 12th of July. The court found that the plaintiff had adequately pled an HTTPS element. So Twilio effectively lost on the HTTPS issue, but they won to kick the case out on the question of whether Twilio, or as opposed to its customer, was the one who initiated the call to the plaintiff. And then the court in an earlier decision had already found that the message was an informational message because it was associated with a transaction he already started with Twilio's client. And so the court said there was consent anyways, so I'm kicking your case for that reason as well. They did give him a chance for a leave to amend, so we'll see what he does there. But a mixed outcome for Twilio. Certainly, not the outcome it wanted relative to its platform. And the court, was on solid ground in saying that the extent to which the platform is used as an auto dialer depends on the facts. And so it's hard to win that issue on a motion to dismiss, so that one's not a surprising outcome given the current state of the law. And then on the same day, out of the Southern District of California, 5-9 won a case where the plaintiff there similarly didn't do a very good job in setting up his pleading. In his First Amendment complaint, he basically invited the court to draw the inference that 5-9's platform was an auto dialer because he got 5 messages over the course of several months. And the court just wasn't buying that because it just doesn't make sense, right? We can obviously all manually make a few calls over the course of a few months or send a few SMS. So the court there likewise said, possibly, but your pleading's not good enough to create the required plausible inference that you used an auto dialer to make any given call or send a message.
All right, perfect. Got another question. I'll read it out to you, Joe, or either Martin. There are some debt recovery agencies, and the agents appear to be threatening sometimes. So are there any litigation on some words that they're using while on a call? And can any customer file a lawsuit under the FCC?
This question raises more FDCPA questions than TCPA questions. I'm going to just reread this again. Give me a second here.
Yeah, this is Martin. I mean, I think that's more of a Fair Debt Collection Act type of thing than TCPA. There are sort of, interestingly enough, exemptions to the TCPA for debt collectors who are, collecting a debt on behalf of the government. It's kind of interesting. The government never wants to usually comply with its own laws. So, there are some nuances to the TCPA as far as debt collectors go, but I think as far as threatening words go, that wouldn't be, under the umbrella of the TCPA.
Okay, perfect. Let's go to the next question. Do you think we'll see a rash of questions challenging the validity of prior express written consent in light of the Sullivan versus all web leads?
I think there already is a rash of litigation around the extent to which consent was achieved in a clear and conspicuous fashion. So I don't know that Sullivan got it wrong. I do think that the plaintiffs' attorneys are now turning their attention more so these days to the validity of prior express written consent, like you say, Dan. So that's been an issue that we've been seeing more this year, but I don't know that it's because of Sullivan, if that helps.
Another question's come in. What are the courts doing with the FCC's potential capacity ruling on the ATDS issue?
This is Joe. I'm seeing the courts struggling with that one as well. It's a lot like the revocation issue where you see courts like the Seventh Circuit say, hey, the FCC has said that potential capacity means that, really essentially anything, and we're going to take them at their word, under traditional notions of, Hobbs Act and deference to the agency. We're going to defer to that ruling and take them at their word. And if they want to have a change, it needs to come from the FCC or Congress, and it's not the court's job to read practical limitations into it. That said, I've seen other courts that say, come on now, there has to be some reasonable limit on this thing, on this concept of potential capacity. And so I've seen cases where they draw a brighter line around either human intervention, which is the typical course, or they just kind of call the bluff on the plaintiff and say, you need more than just a metaphysical possibility. But yeah, certainly it's a gray area in the courts, and they're struggling.
Well, and I guess probably the easy answer to the question is a lot of courts are just waiting to hear from the D.C. Circuit, which we should hear from any day now to maybe illuminate that issue.
Yeah, I've seen an uptick in stays of cases as the wait moves on here. So I do feel like some courts are getting impatient and thinking the decision's got to pop soon. So why are we going to go into all this expensive discovery if the law is about to change? And they're certainly pointing to things that have been coming out of the new PI administration about their view of taking a market-driven, market-based approach to solving the TCPA-related issues.
Perfect. Do we have any more questions? Take the next second or so to go ahead and type them in.
And Marjorie, we can announce the poll question answer if you like.
Let's do that.
Well, it's kind of like the the third grade soccer team where everybody gets a trophy. I think everybody got the answer right because Chief Justice John Roberts did say in oral argument that the TCPA was the strangest statute he had ever seen. But it's probably also correct to say everybody in the audience, and certainly the two presenters, think the TCPA is the strangest statute they've seen. So I think it's one of these where everybody's right.
Awesome. All right. So if there aren't any more questions, just know that if you come up with any questions after the webinar, feel free again to either send a message to PACE, or of course you have Joe and Martin's email address right here on the screen. You can screenshot it or write it down and fire off questions to them at your leisure. So again, thank you for attending today's webinar. And as a reminder, the 2017 PACE Washington Summit is being held at the Renaissance Hotel in Washington, D.C. on September 17th through the 19th, 2017, where Joe will actually be sitting on one of our panels. So come on out and support and hear from Joe and the rest of our panel speakers, as well as the FCC, FTC, and NAGA, the National Association for Attorneys General. So there you go. PACE CCP 2-day live training course and exam event will also be held on September 16th through the 18th, and there are still seats available for that. You can contact me at mondry.godfrey@paceassociation.org if you're interested, and if there are no more questions from both PACE National and Innovista Law, have a terrific day. Bye now.
Thanks for joining, everyone.